My name's Ed Harris, and I'm the Chief Communications Officer at Family Equality Council, and we're delighted to be presenting the webinar version of our Colorado LGBTQ Family Law Guide today in partnership with One Colorado. I'm going to hand things off to Shelby Day, our Senior Policy Counsel here at Family Equality Council, who will introduce the rest of our presenters and get us started on the presentation.
Hello, thanks so much for joining us today. I want to quickly introduce our panelists. We have a very distinguished panel of guests here for the webinar who also worked with us on the LGBT Law Guide for Colorado. We have Rachel Catt, who is an attorney at Harrington, Brewster and Klein, and she has been working on family law exclusively as an attorney since 2002. She's a member of the LGBT Bar Association of Colorado, of the Family Law Institute of the National LGBT Bar, and is on the Family Law Committee of the National Center for Lesbian Rights. We also have with us today Ann Gushurst, who is a shareholder and president at the law firm of Gutterman and Griffiths there in Colorado. She is a highly distinguished family law attorney in Colorado. She's also a member of the Family Law Institute of the LGBT Bar, and she's on the Family Law Executive Council of the Colorado State Bar Association. Both Rachel and Ann have particular expertise not only in family law there in Colorado, but also on LGBT issues. We also have with us Kara Cheevers, who is the policy manager at One Colorado. She works on a range of LGBT policy issues in Colorado and works alongside state agencies in rulemaking and the regulatory process on behalf of LGBT people in Colorado. At this point, I just would like to point out to everyone that the handbook that this webinar is based on, as well as the webinar itself, are not intended to be legal advice. Rather, we intend for this to be an overview of the current state of LGBTQ family law in Colorado. And if you have particular questions related to any of the issues that we discussed today, I would strongly encourage you to reach out to an LGBT family law attorney there in Colorado and get specific legal advice. At this point, I'm going to turn it over to Kara to talk a little bit about One Colorado and the work that they're doing.
Great, thank you all so much. Again, my name is Kara Cheevers. I'm the policy manager at One Colorado. One Colorado is the state's leading advocacy organization for LGBTQ Coloradans and their families. We have a number of policy priorities and programs. The first is to primarily protect the victories that we've seen in the state since marriage equality and relationship recognition. In the state legislature, we see a number of pro-discrimination policies that are in the or that are debated, primarily looking like religious freedom and religious exemption laws. We're also trying to pass legislation to ban conversion therapy and update the process improve the process to update your birth certificate in the state. We also have a pretty extensive health policy program that looks primarily like data collection and research, as well as a Safe Schools program supporting local school districts to implement anti-bullying and bullying prevention education trainings. That's pretty much it.
Great. Thanks so much, Karen. Thanks for the wonderful work that One Colorado is doing. So we want to start today. We're going to give an overview of the LGBT Family Law Guide, which at the end of the webinar, there will be information on how to download that guide. If you haven't already, you can also find it on our website at familyequality.org. And we're going to begin today talking a little bit about family recognition. So in 2012, the state of Colorado enacted the Colorado Civil Union Act. And what this does is it created civil unions in Colorado. Colorado at that time, and actually beginning in 2006, had a state law that said marriage was limited to different sex couples, so limited to a man and a woman. And so in 2013, in response to that, Colorado passed its civil union law, which authorizes any two unmarried adults, regardless of gender, to enter into a civil union. It granted partners all states' rights, benefits, protections, and responsibilities that were afforded to married spouses, so at that time, different sex couples. It's worth noting that the law treats civil union partners like married couples in many respects as far as support, division of property, and benefits. However, there are some notable differences and gaps that remain, such as parties to a civil union who are not married are not allowed to file a joint state tax income return. They can't file a federal tax. They're also not recognized for federal benefits. Dissolution remains difficult due to taxation issues for folks who are who have a civil union, and benefits also can be problematic. And even though we now have nationwide marriage equality, which I'll talk a little bit more about, civil unions still exist in Colorado, and they continue to remain an alternative option to marriage for couples who wish to be in a civil union rather than just getting married. And at this point in time, I'm actually going to invite Rachel and Ann, if there's anything you want to add about civil unions, please feel free to do so before we turn to marriage.
Hi, this is Ann. Two points I wanted to make. The biggest problem I see with dissolution of civil unions is in trying to divide pension or retirement accounts, because you can't do that without cashing out the funds. You can't divide them tax-free like you can with a dissolution of marriage. And the other is, because of the civil union bill, we just ran into a case recently, actually yesterday I think, where a court clerk was not allowing a same-sex couple to file for a decree of dissolution because the civil union bill still has a provision that deems marriages from out of state between two same-sex couples as being a civil union. I'm pretty sure that's going to go away, but we haven't amended our statute yet, so there are some sticky points that remain.
Great, thank you. And in turning to marriage, so marriage equality arrived in Colorado on October 7th, 2014. That's when marriage licenses began being issued. The way that we got there is in 2013, after the Federal Defense of Marriage Act was struck down in a case called United States versus Windsor. There were two lawsuits that were filed in state court challenging Colorado's definitions of marriage. The cases were joined in a case called Brinkman versus Long, and ultimately the state court ruled that Colorado's exclusion of same-sex couples was unconstitutional. So of course, like many of the other marriage equality cases in other states, it sort of wound its way through the appellate courts. And ultimately, as a result of the U.S. Court of Appeals for the 10th Circuit, which Colorado was part of, as a result of two marriage equality decisions that occurred there in other states in the 10th Circuit, in Utah and Oklahoma, ultimately Colorado got marriage equality and marriage licenses began being issued. We got marriage equality nationwide on June 26, 2015. This was a result of a case called Obergefell versus Hodges. The U.S. Supreme Court made clear that same-sex couples had the constitutional right to be married in the same way as different-sex couples, and were entitled to all the rights and benefits attendant to marriage. So what does this mean, that we have nationwide marriage equality? It means that same-sex couples, as I just said, are entitled to all state and federal benefits that are attendant to marriage. Some federal benefits are available to married couples only. So as I said earlier, this does not apply to couples who are in a civil union in Colorado. So that's something that all couples should consider when they're making decisions about whether marriage or civil union is right for them. And of course, that's a very personal decision that each couple has to make for themselves. Ann and Rachel, is there anything you would like to add?
Well, I guess when you're talking about marriage, and since Colorado recognizes common law marriage, that's one of the things that we should talk a little bit about. Rachel? Yeah,
I definitely want to do that. So let's turn it over to Rachel, to you and Ann, to talk some about common law marriage.
So one question I get is, this is Rachel Catt, whether or not a same-sex couple can be in a common law marriage in Colorado, and the answer is yes. Colorado is one of 9 states that still recognize common law marriage, And on the next slide, we're going to talk about what a common law marriage is exactly. A common misconception about common law marriage is that all it takes to become common law married is to cohabitate for some specific period of time. Over the years, I have heard a lot of people tell me, oh, we've lived together for 7 years, so we're common law married. And that's actually not the case at all. Requirements for common law marriage in Colorado include evidence of cohabitation, so they're right, you do have to live together, but you also need a general reputation in the community as married. And a more recent case in Colorado called People versus Lucero states that a common law marriage is established by the mutual consent or agreement of the parties to be husband and wife, followed by a mutual and open assumption of a marital relationship. As you might imagine, establishing that the parties engaged in a mutual and open assumption of a husband and wife relationship can present some problems if you're trying to prove this to a court. Now, I will say, anecdotally, what I have heard and what I have read as well is that if you're trying to prove that an intact marriage exists, that tends to be a lot easier. So for something like an immigration case or a Social Security case or a trust and estates case, it has been easier to prove those. However, in the area I'm most familiar with, which would be in a divorce context, it has been more difficult to convince trial courts that a same-sex common law marriage exists. And that is partially because what the case law tells us as factors that we should look for in determining a common law marriage are things like whether they said husband and wife. Did their neighbors know that they were married? Did they have wedding rings? Did they file their taxes jointly? Did they have joint bank accounts? And of course, many of these things were not available to same-sex couples until very recently. And so one thing that we're trying to do as LGBT family law attorneys is educate the bench and help them try to have a paradigm shift to turn away from heteronormative standards of marriage and have them have more of an open mind about terminology that we may have used to describe our relationship, the extent to which the parties were closeted or just uncomfortable coming out to their neighbors or coworkers or family members, and have them instead focus on items that same-sex couples as well as opposite-sex couples would do only if they were in a committed marital type relationship, like share joint bank accounts, joint investments, joint tax planning or estate planning. Did they go on vacations together or share pets? Did they have children or attempt to have children together? And try to have the court focus on those things that a same-sex couple did have available to them and place less weight on things like, did they say the words husband and wife?
Or wife and wife. I think that some of the things that I'm really arguing for in courts are, did people assume responsibilities that are really marital responsibilities? For example, did they support each other financially? Did they give each other powers of attorney? Because obviously the argument that we're facing is one of just because two people live together doesn't make them married, and aren't you just creating this huge percentage of people who've lived together who now are at risk of being labeled as being spouses? So one of the things that is we're using in these cases is to look at the conduct between the spouses to say, this isn't just a boyfriend and a boyfriend or a girlfriend and a girlfriend. These people are a committed family unit. And it's ironic because we're having some success in terms of convincing courts that, yes, same-sex common law marriage exists, but then they're saying, but not this particular case. And we've got a couple of those cases going up on appeal. So hopefully we should have some better guidance in the next year.
Great. And I think next we're going to talk, Anne and Rachel are going to talk a little bit about family formation. So as we all know, LGBT families have diverse family structures, and they create their families through different ways. Some same-sex couples are raising children who were conceived in a previous different sex relationship. Some adopt. Some use assisted reproductive technology, such as sperm donors, egg donors, or surrogacy. So, Anne and Rachel, I'll turn it over to you to talk more about family formation.
This is Anne. I mean, I think what's happened in the LGBT community is that the formalization of relationships through Obergefell and then our victory in the state has led people to start thinking differently about just what is family to them. And we have had numerous examples of same-sex couples who are raising children. And it could be the biological child of one of the partners, or we had the second parent adoption statute go through in 2007, children that have been adopted by the couples. Adoption is definitely one of the ways that families get started in the same-sex community, along with the assisted reproductive technology. Rachel, do you want to talk a little bit about what goes into adoption?
I do, and I think we'll get to that in the next slide. But one of the things that was mentioned is what to do with children who were conceived in a previous different sex relationship. So presumably in that case, there is another legal parent in the scenario. And what everyone I think should be aware of is that if you have come out since your different sex relationship, the case law in Colorado does offer certain protections. So there is a case that specifically prohibits a court from relying solely on a person's sexual orientation in making decisions about who can have parenting time and decision-making for their children. And likewise, very interestingly, we have in Colorado a case going back all the way to 1973 that specifically addresses transgender parents. And the court specifically found that the parent's transgender status, so long as it did not affect the relationship with the children, could not be considered as a reason in and of itself to deny parenting time or decision making. So those are some wonderful protections that we do have in Colorado. I will also say that depending on the county where you are and the judge that you get, there is of course still a certain amount of implicit bias. There are judicial education committees trying to assist judicial officers with this, but that does still exist. But the good news is we do have these case laws, this case law that does protect us to a certain extent.
And while we're talking about children who are conceived in previous relationships, we should also talk about the fact that just because a child has a legal biological parent doesn't necessarily divest the same-sex parent from asserting legal parental rights. We don't have any cases in Colorado yet where they've recognized more than two parents. I suspect that that's going to come. But under Title 19, if you have a presumption to being a parent because you've raised a child and held that child out as your own, you still may have legal protection as a legal parent. And the reason I mention legal is that although there are cases that recognize psychological parents, people who have a parenting relationship but not the legal status, their rights to assert parenting and to be awarded parenting time and decision making are considerably less than the legal parent's rights. So you should take a look when you have one of these cases as to whether or not you want to try and establish a legal recognition for the parenting role that your client has assumed.
Okay, I think we're ready for the next slide. So generally speaking, about adoption in Colorado, any person 21 years of age or older may petition the court to adopt a child. LGBTQ individuals are not prohibited from adopting in this state, but they are not specifically protected either. You should also know that a person with a living spouse or civil union partner must jointly petition to adopt the child, unless there are certain specific circumstances, like one parent is already the natural or adoptive parent. There's several different kinds of adoption. There's a private adoption, of course, the public child welfare system, and what we will speak more about today are step-parent adoptions and second-parent adoptions, which are also available in Colorado. And the next slide, please. So in Colorado, I wanted to talk about what the rules are for assisted reproductive technology. We do have some guidelines for egg donation and sperm donation. And in that case, the spouse of the biological parent is presumed to be the other parent. And that's the key thing, that if you are married and your spouse has a child by assisted reproductive technology, you are assumed to be the parent of the child. So for example, if you're a lesbian couple and you use a sperm donor, and you give birth to the baby, your wife is presumed to be the parent of that child, which is a great thing that we got with marriage equality. I will say, however, that it's really important to make sure that you do those sperm donations under the quote-unquote supervision of a licensed physician. If you don't, that presumption does not apply to you. So it's really important to get a doctor involved, get a lawyer involved. Those contracts can be really helpful if the dispute arises later, to figure out what you all intended at the beginning of the process, and it can help the court sort out who has what rights at the end. With regard to embryo donation and surrogacy, Colorado is a great place to be a surrogate because we have no state laws specifically addressing surrogacy. So Colorado is a friendly environment for surrogacy and as well as embryo donation. But again, contracts are absolutely critical in something like that. Please do not try that on your own. And there are several fantastic attorneys in Colorado who specialize in those contracts, who I highly recommend that you engage if this is a road that you want to go down.
And that brings us to talking about protecting the relationships that you create as a family. One of the hardest things that we as family law attorneys deal with are when a same-sex couple comes into the situation where the relationship is faltering and one person has a biological connection to their child and the other one doesn't, which is why we're going to talk to you a lot about how you can protect your parenting relationships. Obviously, there are presumptions that when a child is born into a couple who is joined through marriage or civil union, you can get your name on the birth certificate, and that's a presumption of parenting that gives you some standing. But under full faith and credit, there's at least one case where birth certificates weren't recognized in a different state, and as has been pointed out in numerous cases, just because your name's on the birth certificate doesn't prove that you're the legal parent. It's a presumption, it's an indication that you're a parent, but you're much more protected if you have an actual court order that says you are this child's parent. And there's a couple of ways of getting those. Obviously, you can have an adoption, or you can have what's known as a declaration of paternity. And there's also at least case law that indicates that if you go through a divorce and there's a child support order entered, that divorce decree is also a court order establishing legal parent status.
So Anne, just so everyone understands what a presumption is, I think what it means is that if you have one of these factors that applies to you, the court will presume or assume that you are a parent, but it's not guaranteed. That presumption could be challenged in court, and you may or may not prevail. Is that right?
That's correct, and that's under Title 19-4-105, lists out all the presumptions. And those presumptions also apply to assisted reproduction, which is 19-4-106. And basically what a presumption means is that if you've done or are in the situation where, for example, your spouse gives birth, or you've attempted to marry a woman within, I think it's 300 days of the birth of a child, or you've held the child out, there's like 12, I think, different presumptions in the statute, that the court will look at you as a presumed parent. Where that becomes challenging is it's entirely possible in these situations that more than one person can have a presumption of parenthood, and then you go to court and have a little contest as to which presumption, serves the weightier public policy guidelines, and there's some guidance in the statute as to that as well. I think this is why, this leads into why would we get a court order if we have a birth certificate. And again, birth certificate doesn't prove that you're a legal parent, and in particular, if you travel outside of the state where the birth certificate was issued, there have been some really terrible cases where other states have refused to recognize birth certificates as giving a parenting relationship legal validity. So let's see, we are on court orders establishing parentage. I think you wanted to talk about the difference between step-parent and second-parent adoption, Rachel.
Right, so we'll talk about the two different kinds of adoptions, and then Anne will talk about a different kind of court order that can also protect you as well and might be better for your family in certain circumstances.
And Rachel, before we go there, if I might interject really quick, this is Shelby. So I just really want to drive home the point that Anne was just making. And so to be very clear, if you're a married couple in Colorado and you have a child born into your relationship, both parents should be on the birth certificate, but all of the national LGBT organizations, Family Equality Council, and all of our sister organizations strongly urge you, as Anne said, to get a court order confirming that both parents, including the non-birthing or non-biological parent, is a legal parent of the child. And I think Anne just did a good job of going over why that's important. But the birth certificate itself is based on the relationship between the parents, not the parent-child relationship. It is not a court order. So it's absolutely imperative that you protect your parent-child relationships of both parents to that child and get a court order. And we're going to talk a little more about that.
Yeah. And there's various ways you can get court orders. And just so everybody understands that under constitutional law, other states are required to give full faith and credit to a court order. They're not required to give full faith and credit to an administrative document, which is what a birth certificate or social security card is.
Exactly.
So, well, let's talk a little bit about step-parent adoptions, Rachel.
Okay, so now that we have civil unions and certainly marriage in Colorado, a step-parent adoption is available to any married couple. A step-parent adoption allows a non-biological or non-birthing parent to adopt their spouse's or civil union partner's biological or previously adopted child. This is a great protection. It's not that difficult. It's largely form-based. I put the link on there to find the court documents that you would need to go through the process, at least get started. As always, reaching out to a family law attorney to make sure you're not going to run into any unforeseeable roadblocks is always a great idea. There's oftentimes something that comes up, but plenty of people do go through this process without an attorney as well. It's not necessarily a bad idea to give that a shot. Some requirements are you have to be married to or in a civil union with the other parent. There can't be any other legal parent floating around. You do have to submit to a background check. There's a small fee for that, but it doesn't take that long. You'll have a court hearing, which is, for the most part, a formality, and it does require the consent of your spouse. And I think Anne will get into why this is one of the reasons why a step-parent adoption is not always available or preferential for your family.
So I just want to
say that the process varies by county, but I would say on average it probably takes 6 months to get this process completed.
The one thing that we should also bring up is that the fast step-parent adoption is when there's no other legal parent. So that happens in cases where you've got a surrogacy or assisted reproduction. But step-parent adoptions are also possible when you do have an other legal parent. and in that situation, you have to give notice to the other parent, and there's a 1-year rule that the legal parent has to have been not in the child's life or consents to the child's adoption. So that happens in cases where the legal parent has, basically not supported the child and not had a relationship with the child, in which case the child can be available for adoption via step-parent, but you have to terminate the legal relationship with the prior parent first. And certainly that has happened in several of my cases with same-sex couples who are raising a child that's the biological child of one of the spouses, and the other parent just hasn't been involved in the children's lives for some time.
Yeah, Anna's absolutely right about that, and that would definitely be an occasion where it would behoove you to reach out to an attorney to guide you through that process. And going back to why it's important to get a doctor or a lawyer involved in the first place is if you have a sperm donor and the sperm was not donated to a licensed physician, then this is exactly the kind of problem that you could run into.
Yeah, in fact, our first holding out case was that exact scenario in the state. So second parent adoptions, I think we're ready to move on to that.
Yeah, second parent adoptions, as Anne mentioned, became available in Colorado in 2007. They were a wonderful avenue for same-sex parents to adopt their children and form that legal relationship when same-sex couples were unable to be in a legal relationship with each other through a civil union or a marriage. The second parent adoptions do still exist, and if you're not married to your spouse, that's one way to get this handled. It's similar to a step-parent adoption, except that you do have to engage in a home study. However, there's a process to ask the court to waive a home study. So, for example, if you've been living with this child and parenting this child for a number of years, and the other parent consents, which is required in this type of adoption as well, then there's a decent chance that the court would waive the home study or truncate how thorough or invasive the study has to be.
I believe that second parent adoptions also require the consent of the first parent. And that should be on this slide, and I'm sorry I missed it. But and the reason I bring that up is that second parent adoptions and step parent adoptions are really problematic when the couple is in the process of having marital issues, which is usually when people start thinking like, oh dear, if my relationship's failing, how do I protect my parenting rights? Because both of these adoption methodologies require the other parent who has a legal relationship to participate and consent to the adoption.
Right, exactly. So if you and your spouse start arguing and your relationship starts to fall apart, unfortunately, we oftentimes see biological mothers who will do everything in their power to interfere in the relationship in the life between, or the relationship of their children with the non-biological spouse, where they can get into a lot of trouble, and that is where a declaration of paternity or maternity might come in.
Yeah, and then sadly, I would say that the majority of cases where I'm dealing with couples who are separating their children have required a declaration of paternity and maternity to occur because it's, I guess, a tempting way to assert parenting rights is to say that your spouse doesn't have any legal rights. So a declaration of paternity is done under Title 19, which is the Children's Code in Colorado, and it's done under 19.4.105 or 106. And basically what you do is you affirm parental status and you get a declaration of paternity and maternity. Consent is not required. The court makes a determination. The things that you need to know as a practitioner are that you are required to give notice to all presumed parents. So anybody who has a presumption, even a sperm donor, must be notified. And then the forms are on the court websites, and you follow a procedure. It generally, if there's not a huge contest, it can be done within 3 months. I've got a couple of them going right now where we're looking at probably a 6-month time frame for resolution. And if it's contested, then you may have to hire an expert to look at what's going on with the child and to give some expert testimony. But generally speaking, I've been pretty successful under this statute for establishing legal rights for same-sex parents who are not biological parents.
And thank you both for that. I want, before we move on to another topic, I just want to point out something I think that both of you have mentioned as very experienced practitioners on the ground dealing with family law issues. When we begin our relationship and at the point at which we start our family, like any couple, we typically don't expect that we're going to run into relationship problems. It's possible that those already exist at the time that you're having children, but whether you're having problems or not, it is imperative that you protect your parent-child relationships and make sure that both parents are protected, because unfortunately none of us have a crystal ball, and it's just important, whether it's because of death of one of the parents or because the relationship starts to go south or the couple starts to experience problems. Things can change, and we all have seen that as practitioners in the field. And so when you're creating your family, it's really important that everyone's intentions are set forth in agreements like donor agreements or parenting agreements. But most importantly, it's important that you ensure that child relationship with both parents is protected from the outset, so that no matter what occurs, because things do happen, as you're hearing, that neither parent can validly challenge the legal relationship or rights of the other parent, because that does happen, and we see it over and over again.
Yeah, it's tragic. It's like the hardest cases I deal with. They're just absolutely tragic. I'm looking forward to the time when we have some same-sex dissolutions with children where paternity and maternity is not an issue, because there is case law in Colorado that says the decree of dissolution in which child support is ordered or parenting time is awarded is a de facto declaration of paternity and maternity. So if you have a same-sex couple that's divorcing and neither one challenges the legal status of the other, you don't have to go through a separate procedure to get a declaration of paternity and maternity, and the decree of dissolution will serve as a declaration of parental rights.
And what I'm advising couples as to why they should make sure that they have a real clear legal standing with their children, I try to think about it from the kid's perspective as well. Like, how many times does a child need to prove that they're the legal child of one parent or the other? This can come up when the parent dies and maybe the parent doesn't have a will and they're trying to inherit, or if the parent is injured and they need to get some funds from Social Security, or the parent retires or dies. Student loan applications, school stuff. I mean, there's lots of times when a kid needs to prove that they're the child of the parent, and depending on what jurisdiction you are or what organization or how conservative your organization or location might be, they might say your birth certificate's not enough, and they want to see a court order like Ann has been discussing to really prove that your parent is your parent.
I just find that whole notion so upsetting, because we just don't do that to heterosexual families, do we? So Social Security, passports, and children. I think that's our next slide, isn't it? Yes.
Okay, right. So I was getting into that a little bit already. This slide talks about Social Security. I will say the Social Security Administration, as far as I understand, will recognize an adoption, no problem. They will also recognize these paternity and maternity declarations that Ann was discussing, but it's more of an extensive process. Also, you should make sure that you're both listed on your child's passport and other areas as well.
Okay.
That's all. That one.
So estate planning. I'm not an estate planner, but I will say that some estate planning tools are critical, particularly if you run into a contest of common law marriage. It's helpful to show that you've named somebody in your last will and testament. There's a more practical reason, too, for same-sex couples to make sure that they have a last will and testament, because if you die without a will, your spouse is only entitled to a portion of your estate, and other relatives then have a claim. And that can pose problems, particularly if you've been in a long-term relationship and you've done your financial planning together, and both of you are banking on the fact that what you have is going to sustain the person who dies second. You really need to have a last will and testament. Advance directives for health care are also critical to same-sex couples when they run into the situation where there's already terrible discrimination against old people to begin with. But same-sex elderly people have probably a much higher rate of discrimination. And you can run into a situation where children or other relatives or facilities don't recognize the right of the spouse to have a say in helping plan for the health care and palliative care for their spouse. That can be taken care of with a living will, and it's really important that people understand, particularly with advanced death directives, that just doing your living will is not enough. The statute requires that it be registered with the state, and you should follow the statute in doing these types of documents. And then obviously financial power of attorney, so that your spouse can act for you if you're incapacitated or out of state, is also really important, because again, institutions don't always recognize same-sex couples as being legitimate spouses to each other.
Great, and I would add, this is Shelby, I would add that, these are documents that as attorneys we recommend that all couples, LGBT or straight have, or all people have. It's a way to protect your spouse, your partner, your family. It's really a gift to your family if something should happen, so that they don't have to try to understand what you might have wanted or to try to make that happen in very difficult times when someone is either incapacitated in the process of dying or has passed away. This ensures that what you want to happen with your property, potentially with guardianship of your children, with your own healthcare decisions and your finances, it allows people to carry out your wishes, to understand what those wishes are, and can prevent a lot of discord amongst family members. The reason it's particularly important for LGBT people, as Ann pointed out, is, we face discrimination, and especially, Colorado is a particularly progressive a state. There's still discrimination alive and well there against LGBT people, but these are documents that can be particularly helpful if you're traveling to other states that are not friendly to LGBT people if something were to happen, especially with the Advanced Healthcare Directive and Financial Power of Attorney and some of the other documents that are listed in the guide. So we strongly encourage all LGBT people and couples, especially parents, to have these documents. Okay, and so I think from there we're moving on to name change. So under Colorado law, transgender individuals are able to change their name and gender marker. The process for doing this is a court process. You must submit a notarized petition to the county court of your residence. It requires a criminal background check. It also statutorily requires that you give public notice. That's not unique to Colorado, actually. Most states require notice. It's to prevent fraud from creditors and any name change. And this is also typically required for transgender individuals. In addition, you can get your birth certificate amended if you were born in Colorado to reflect your changed name and your true sex. To do this, you have to submit the certified copy of the court order changing your name and indicating that, quote, your sex has been changed by surgical procedure. So what does that mean? The Colorado Department of Public Health and Environment has stated that for purposes of Colorado, having your sex changed by surgical procedure means that your gender has been changed via sex reassignment surgery, is a process where a person's physical characteristics and or social gender role are changed to reflect the sex opposite to that determined at birth. And so what this means is that you need your treating medical licensed physician to be able to submit documentation saying that that you have undergone social transition and what they would consider having changed your sex. And so, you know, this is an area where there are sub-attorneys in Colorado who are practicing, who do provide assistance for name and gender changes, and I would strongly suggest, if you have specific questions, to reach out to those folks. You also can get your name and gender marker changed on your driver's license in Colorado. To change your name, you have to submit the name change first to the Social Security Administration and bring a certified copy of your court-issued financial decree of name change to the local DMV office. To change your gender marker, you actually have to submit medical information authorization form completed by your licensed physician to a local DMV office. And so typically these are processes that someone can do without a lawyer, but we find in many states that it does help where there are questions to consult with an attorney or organization who specifically works on these issues. Kara or Ann and Rachel, is there anything you guys want to add on that?
Yep, I did. I just want to mention that we have a fabulous organization in Colorado called the Colorado Name Change Project, which is headed up by an attorney named Emma Shin, and she has helped thousands, the organization has helped thousands of transgender people change their name and other documents. So if that's something you're interested in, it's Colorado Name Change Project.
Okay. Now, I don't know very much about changing, this is Ann, names other than there's also the provision to allow you to change your name as part of a decree of dissolution, and it's basically you just give notice that you're changing your name and you can do it that way. If you're changing the name of a child, that also can be done as part of a paternity action or a decree of dissolution as well.
And this is Sarah. I don't have anything else to add.
Great. And so it sounds like the Name Change Project is an organization that if you have any specific questions, I think it was Rachel who said, I think that's the best organization probably there in Colorado to reach out to, and they certainly can provide you with guidance. And so we appreciate the work that they're doing. So to give a quick overview of non-discrimination protections, Colorado, as I said earlier, is one of the more progressive states in the country when it comes to the rights of LGBT people. Colorado law provides statewide non-discrimination protections for LGBT people in employment, housing, credit, and public accommodations. In 2007 and 2008, the Colorado legislature passed amendments to the Colorado Anti-Discrimination Act, also referred to as CADA, to include protections against discrimination expressly, prohibiting discrimination on the basis of sexual orientation and gender identity. And actually the way that this happened in Colorado, the statute itself refers to sexual orientation, but then goes on to define sexual orientation as a person's orientation towards heterosexuality, homosexuality, bisexuality, or transgender status. And so it includes, by definition, all LGBT people. In Colorado, one thing it's important to note specifically in the employment realm, the standard in Colorado for prohibiting discrimination actually is much more generally prohibiting employment discrimination, provides more protection than federal law in that CADA applies to all Colorado employers regardless of size, and under federal law the threshold is actually an employer that has 15 or more employees, and so there are more extensive protections generally for employment discrimination in Colorado. We also encourage, beyond state law, we encourage folks always to think about the fact that individual employers also oftentimes provide protections from non-discrimination in their policies and practices, and so it's important to also know if your company has non-discrimination policies in place that would provide you protection. Under federal law, there's no express federal non-discrimination protections for LGBT people in employment, housing, or public accommodations. Under Title VII of the Civil Rights Act, there have been some courts that have interpreted protections against sex discrimination to include LGBT people in certain circumstances. That's mostly applied to transgender people. The courts across the country are kind of all over the place on when those protections actually apply to lesbians and gay people or sexual orientation-based discrimination. So it really depends on where in the country you live, but the EEOC has for some time, beginning in the Obama administration, actually, they had interpreted Title VII as protecting LGBT people, and of course the Trump administration has recently reversed course as far as that guidance. And so that's actually an issue that one of our sister organizations, Lambda Legal, is actually asking the U.S. Supreme Court to consider and to provide an opinion on, to sort of settle the disputes amongst the federal courts on whether LGBT people are protected under Title VII and under what circumstances. So I would be watching out for that to see if the Supreme Court actually takes that case and weighs in. One other thing that I wanted to add with Colorado's protections from discrimination in public accommodations, one case that I wanted to highlight that's important to note that is currently before the U.S. Supreme Court and oral argument will be heard on next week on December 5th, is a case that the ACLU LGBT Project has taken to the U.S. Supreme Court. It's Masterpiece Cake Shop versus Colorado Civil Rights Act. And this case will decide if private business owners and other places of public accommodation can discriminate in the name of religion or speech. And so very quickly what happened there is in 2012, a bakery there in Colorado refused to make a wedding cake for a same-sex couple who was planning to marry in another state and then have their reception there in Colorado. They filed a claim with the Colorado Civil Rights Commission and won. The baker in that case appealed, and the appellate court in Colorado upheld the lower court decision, finding that the baker had violated the CADA and Colorado's prohibition of discrimination in places of public accommodation. The Colorado Supreme Court declined to hear the case, and the baker actually filed petition for certiorari in the U.S. Supreme Court, asking the U.S. Supreme Court to take it. It took the case, and so that case has been fully briefed, and as I said, oral argument is next week. So to be really clear, I think it's important to point out, both for purposes in Colorado and across the United States, this case is not about wedding cakes, and it's not just about LGBT people. This case is a very big deal. It will determine whether or not in Colorado and the other states, I believe there are 18 other states that have non-discrimination protections in public accommodations, whether a private business or place of public accommodation can basically discriminate against an LGBT person or others based on religious beliefs or their free speech. And so free speech comes in because the baker here said that making cakes was inherently artistic, and forcing him to make cakes for a same-sex couple forced him to engage in certain speech that he didn't agree with. And so both the religious argument and the free speech argument are before the U.S. Supreme Court. And effectively, if the bakery is successful in that case, it would mean that businesses and other places of public accommodation could go back to hanging up signs in their window to say that we serve only certain people here. So no gay people here, and no unmarried couples are permitted in this hotel. And really kind of where that line would end as far as the discrimination is really hard to tell, but we know it's beyond the LGBT community and beyond this context. So watch for that case and how that turns out. And so with that, I want to turn it over to Kara to talk a little bit about schools and hate crimes in Colorado.
Great, thank you. So in Colorado, like we talked about, the Colorado Anti-Discrimination Act added non-discrimination protections for LGBTQ public school employees and students. Schools are now required to have written non-discrimination policies that basically state that districts are subject to federal non-discrimination clauses, and that does include on the basis of sexual orientation. And as we discussed, sexual orientation as it's defined in Colorado includes transgender status and gender identity, therefore encompasses the entire LGBTQ community. In Colorado, transgender students have the right to use bathrooms, dress, and participate in school activities in alignment with their gender identity. We also passed a 2011 anti-bullying law that protects students from any written or verbal expression or any type of bullying that could be on real or perceived sexual orientation and gender identity. With that law, we also now have the School Bullying Prevention and Education Grant Fund housed at the Department of Education, which provides funding for school districts to implement anti-bullying programs. One quick thing to note, in federal law, Title IX, which prohibits discrimination on the basis of sex or gender, has been applied to protect students who are sex or gender nonconforming. And there have been a number of cases that support lesbian, gay, bisexual, and trans students along that. There's an important thing to note with the Trump administration, who's verbalized wanting to rescind this in their policies. However, the U.S. Court of Appeals, so the Seventh Circuit Court, unanimously held that trans students are protected under Title IX and the Equal Protection Clause of the U.S. Constitution. So basically stating that while it doesn't explicitly have a protection for sexual orientation or gender identity, we see success in students being protected. And a quick wrap up on the hate crimes. I'm all set with this. Basically, the important thing to note with state law, LGBTQ people are protected from by hate crimes. It explicitly includes actual or perceived abuse based on your sexual orientation or gender identity, again, with the way state law is written. And then with the federal law, the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act included LGBTQ people, and that applies specifically to a number of different federal agencies. And I'm all set. Any questions?
I think that's great. Well, thank you so much to our presenters for your expertise and for your work on the guide and on this webinar. And thank you for everyone who has attended this webinar live, and for those of you who will listen to it in the future. There is a link on this last slide to download the guide. If you have specific questions about things that are in the guide or that we've discussed today, then our names and email addresses are on this final slide. And we will also make the webinar available on our website, and I believe our presenters may also make it available on their websites and on the One Colorado website. And so we would encourage you to look at the guide, to download it, to encourage others to do so, and for folks who you know who weren't able to make the webinar, we would ask you to encourage them to take a look at the webinar once it's on our website. Thank you so much, and thanks again for those of you who joined us today, and to our presenters.